The Murder Shelf Book Club contains disturbing content related to real-life crimes. Listener discretion is advised.
The way the case came to a legal conclusion in 2011 with an Alford plea that set the West Memphis 3 free had also robbed me of a victory that I should have gotten straight up in a new trial. No reasonable jury would have convicted any of the West Memphis 3 after the world's best forensic experts had given their testimony in 2008 and 2009, and the state of Arkansas knew it. Dan Stidham, A Harvest of Innocence, the untold story of the West Memphis 3 murder case. Welcome to the Murder Shelf Book Club podcast. I am your host, Jill. This is episode 103, Confession Suppression, A Harvest of Innocence, the Untold Story of the West Memphis 3 Murder Case by Dan Stidham and Tom McCarthy. A lot of foundation was laid in our first episode, 102, Righteous Malice, the nature of the crime that killed 3 little boys, Christopher Byers, Michael Moore, and Stevie Branch, back in May 1993. With the satanic panic raging, suspicion fell on the outcasts, who didn't quite fit into West Memphis society. 18-year-old Damien Echols, Jason Baldwin, and Jessie Misskelley were just teenagers. Evidence included Metallica t-shirts and Stephen King books. I mean, hardcore Satanism. Listen, I know it's laughable today, but the fear was quite real 30 years ago. Dan Stidham took the case, planning to negotiate a plea deal for 16-year-old Jessie Misskelley to avoid the death penalty. He believed Jessie had watched the crime taking place and wasn't actually a participant. Now, Jessie was far from helpful, however, which drove Dan and his co-counsel, Greg Crow, crazy just trying to get a sense of what the hell actually happened. And then, more than 100 days into planning the defense, came Dan Stidham's epiphany. Jessie Misskelley wasn't helpful because he had no idea what happened. He was innocent and was at a wrestling match with friends the night of May 5th, 1993. Well, if Misskelley was innocent, it was likely the other members of the West Memphis 3 were as well. So if you haven't listened to episode 102, please stop and go back and listen. This book is Dan Stidham's memoir with many subtle nuances and critically important information that I had never heard before, and it's really necessary to understand. We had left Dan feeling optimistic. The heck with a plea deal. They had this. Jessie was innocent. They'd call his alibi witnesses, plus 2 world-renowned experts, one in the phenomenon of false confession and the other on polygraphs, who were consulting pro bono, all in the name of justice. Well, the trial was coming closer and closer, with motions and briefs filed and court appearances happening. Now, the world believed that this was a fait accompli, that the West Memphis 3 were guilty. But in 1993, Arkansas had just passed a new law making it impossible to execute an inmate deemed, quote, mentally retarded, end quote, by the court with an IQ score of 65 or lower. That is the vernacular of the day. Don't get angry at me. The law also allowed documentation to be introduced that would put an IQ above 65 as being within the realm of mental retardation. Thus, Dan intended to prove that Jessie's recent IQ score of 72 was one such instance. Judge David Burnett, however, was irritated that Dan made the request for a hearing on this issue. His bias towards the prosecution was legendary. Now, acquiring an expert psychologist was proving horribly difficult, as Dan worked his way down from world-renowned experts to the locals. No one wanted to be involved with the satanic ritualistic homicide case. The one he did find, a local novice, only agreed to testify when assured that he might be compensated by the court after the trial. This psychologist would testify that Jessie was borderline in terms of intellectual functioning, reaching the cognitive level of a 5-year-old child. With Christmas a few days away, Judge Burnett rendered a verdict using his latitude and discretion. Jessie had showed evidence of, quote, street smarts, end quote. Thus, he was not mentally impaired. Oh, and secondly, he could be executed. Now, this is a terrible ruling, but not the worst by far. The night prior to the trial, Dan had learned that his psychologist wasn't licensed to practice psychology in Arkansas. The guy had lied. Informing Judge Burnett, he refused the defense time to get a replacement psychologist to evaluate Jessie, and this was beyond catastrophic. Burnett ruled that Jessie would stand trial as an adult. Oh boy. Well, about a month before the trial was to begin, Arkansas State Police diver Joel Mullins was dispatched to Lakeshore Trailer Park, entering the water right behind Jason Baldwin's trailer. A tip alerted the media, who arrived in droves, witnessing. 15 minutes later, a scary-looking knife was found and packaged as evidence. How odd that it was located so quickly. Well, during the trial, the West Memphis police would inform Dan and Greg that they had this knife and that the trial was on delay as it was sent off for DNA testing. Well, it turns out that the lab they sent it to was not accredited, which is truly astounding. Media reported and the newspapers blasted that the knife was found behind the Baldwin trailer, speculation erupting that this was the murder weapon and confirming the belief that most had that the teens were guilty. 20 years later, retesting the DNA on this knife produced no results. The West Memphis Police Department would allege that this was the knife used in the killing. Many years later, the West of Memphis documentary would reveal that this knife was thrown into the lake by Jason Baldwin's mother a year before the killings. It had no relevance to the case whatsoever. The point is, this rampant speculation did serious damage to justice and to the defense. Now, another knife came into play, one given to the HBO filmmakers, Bruce Sinofsky and Joel Berlinger, by John Mark Byers, the stepfather of slain 8-year-old Christopher Byers. Now, this was a bizarre occurrence, which piggybacked on the numerous outlandish statements by John Mark Byers. Byers gave the cameraman a knife, which appeared to have blood on it. Finding this disconcerting, these HBO filmmakers turned it over to their attorneys in New York City, who in turn gave it to West Memphis Inspector Gary Gitchell. By now, Berlinger and Sinofsky were concerned that Byers could be the murderer. Later, we would all learn that his alibi was pretty solid. But still, it took Gitchell a long time to finally admit to having this bloody knife at all. Blood typing would determine that it matched the types of both John Mark Byers and Christopher Byers. John Mark Byers would make various statements about this knife, that it had never been used, that he had used it and had cut himself, which accounted for the blood, although he didn't actually recall that happening. This is a very different guy, and there is nothing wrong with that. Now later, a supposed bite mark on Stevie Branch's forehead, which is not referenced in the original autopsy, ignited a frenzy of conjecture, especially after Byers had all of his teeth removed, again for a variety of inconsistent, conflicting reasons. This prevented his bite mark from being compared to the one on Stevie. Kind of fun fact, none of the West Memphis 3 bite marks matched this supposed bite mark. And today, bite mark comparison is no longer admissible, as it is just not scientifically reliable. Next up, the hearing to suppress Jessie Misskelley's confession. This was January 13th, 1994, which was literally days before the trial was to begin, coupled with a motion to prohibit the introduction of truly horrible photos of the victims. Gruesome beyond belief, these would greatly prejudice a jury. Dan and Greg knew that they would never get all of the photos thrown out, but limiting them would certainly help. After seeing these photos, Dan knew he would never sleep well again for the remainder of his life. Dan knew firsthand that Judge Barnett had a terrible habit of exhibiting very biased facial expressions and body language, all anti-defense, to manipulate the jury and thus the outcome of the trial. As a consequence, Dan filed an additional respectful motion that requested the court refrain from, quote, engaging in language or conduct, or permitting conduct in the presence of the jury, which would amount to a comment on the evidence as prohibited by the Arkansas Constitution, end quote. Judge Burnett did not appreciate the motion, nor did this stop his facial tics and body language. But it was on the record, something an appellate court would notice. In the weeks leading up to the suppression hearing, death threats had been received by all 3 defendants, as well as Jessie Misskelley Sr. Dan's wife, Kim, reported that people were approaching her at work, church, in stores, questioning why on earth Dan would represent the satanic child killer. Well, as a result, both Dan and Greg Crow would install alarm systems at home. Now it was time to pick up experts, Dr. Richard Offshee and Warren Holmes, who were arriving at the airport. They needed to be established in hotels at Dan's personal, painful expense, and the men began reviewing their files and testimony. Dan was confident in their abilities, having no faith whatsoever in Judge Burnett. The suppression hearing. This blew my mind, the first of many times while reading this book. A little bit of backstory. Dan and Greg had previously begged Judge Burnett to allow them to depose the police officers who had interrogated Jessie Misskelley when he confessed. Burnett had repeatedly refused this, but he had allowed them to talk to the officers about the circumstances surrounding the confession. But the officers had refused. What? Well, layperson that I am, I do not get this. How can the defense not be permitted to interview the officers involved in any aspect of their client's arrest? All right, I'm baffled, and legal minds out there, please help me with this one. I think this must be peculiar to Arkansas because it doesn't make any sense to me. The suppression hearing now began with Dan wrangling with Judge Burnett over the officers' quote, failure to follow his instructions and meet and talk with them as part of the discovery as the judge had directed, end quote. Now, Judge Burnett ruled that the officers had every right not to make themselves available. Next, Dan requested 24 hours to review their testimony and submit a brief once they had given it, since they had no idea to what these officers would be testifying today. Burnett's reply was basically, maybe. He would listen, decide on this, and determine if a brief were warranted. All right, it was clear he had no intention of making the officers follow his order, which is what Dan anticipated. And I was fuming. The arrogance on display by Judge Burnett is reprehensible. While sworn in, Detective Mike Allen took the stand, with Dan wanting to nail down whether he had complied with Rule 2.3 of the Arkansas Rules of Criminal Procedure. This is critically important. This mandated that a police officer make it very clear that anyone who's come into the police station for questioning is under no compulsion to say anything. Quote, if the Rule 2.3 warning is not given, then anything that the person tells the officer at the station is automatically excluded from evidence with absolutely no exceptions. End quote. Dan suspected Detective Allen had not followed Rule 2.3. So his first question, what rights, if any, had Detective Allen advised Jessie Misskelley before taking him to the police station to question him? Allen replied, quote, Misskelley was not a suspect, so I didn't advise him of any rights. End quote. Boom. This should be a slam dunk. More questions came and were answered, but none was more important than this first question. The prosecutors now played the full of Jessie's confession as the media, quote, salivated like Pavlov's dogs, end quote. Now, previously, parts of the confession had been published in the local newspaper, which had copyrighted what they published, and that prevented other media outlets from capitalizing on it. Now, with it played in open court, it was fair game for all of them. And salivating, they ran out of the court to meet their 5 p.m. deadline. This is when Warren Holmes and Dr. Offshee were testifying, with the vast majority of the media missing it. Now, the confession would be plastered all over the front page, with the false confession testimony and Jessie's passing the polygraph testimony regulated to the B section of the newspapers, if it was covered at all. And the HBO cameras were absent that day too. So the best evidence of Jessie Misskelley's innocence would never make it into the public arena. And man, I wanted to throw up. Warren Holmes testified that not once did Jessie Misskelley attribute any conversation during the crime to the victims. Nothing. Nor did Jessie ever state how he felt about the horror unfolding, both being highly unusual, leading to valid, grave concerns about the validity of the confession. Coupled with the multiple discrepancies about when the murders occurred, how the boys were tied up, and the like, Holmes believed Misskelley was making it up to end the endless interrogation, which came in at over 12 hours. Asked if a polygraph can contribute to a false confession, Holmes confirmed it can, and proceeded to tear apart prosecutor Brent Davis's case. Dan would later provide a reporter with a copy of Warren Holmes's analysis of Jessie Misskelley's polygraph, which indicated he had been truthful, which contradicted the police telling Jessie he was, quote, lying his ass off, end quote. When this appeared in the newspaper, prosecutor Brent Davis was infuriated, and Judge Burnett threatened to throw Dan in jail for contempt of court. So wait, law enforcement can leak part of Jessie's confession to the media with no consequences, but the defense cannot share with the media and should just let the jury contamination continue unchecked. All right, this is such a colossal mess. Next up would be Dr. Offshee. Then he told Dan he couldn't testify today. Well, flabbergasted that his star witness was balking, Dan stammered, why? Offshee explained that after listening to the two police officers' testimony, he needed to regroup and reassess his conclusions. So once again, conducting the depositions of those officers before the hearing would have been crucial. And regardless of this outcome, the trial was 6 days away. Judge Burnett, vibrating with excitement, began to speak as he was interrupted by reporters entering into the court. Now, with media witnessing, Dan quickly asked for a 24-hour delay due to the court's refusal of the opportunity to depose the officers in advance. He now needed to do so, a very reasonable request. Fuming, Burnett granted the 24 hours. he directed Dan to send the amended motion to suppress to the prosecutors, who would have until noon on Saturday to respond. Burnett also announced he would reveal his decision to the media at a press conference from his living room on Saturday, January 15th, 1994 at noon. What the hell? Well, this is a first for me. Racing to the office, Greg and Dan began updating their motion to suppress, highlighting Detective Anthony's testimony on violating Rule 2.3, faxing the judge and the prosecutors. All right, a little bit more on Arkansas's Rule 2.3. There's 50 years of case law behind this. And again, if violated, statements made cannot be used under any circumstances. This is not a right in the U.S. Constitution, but it is an enhanced right from the Arkansas Rules of Criminal Procedure. So 50 years duration here. And Allen testified that he had not advised Misskelley of any rights. Should be a slam dunk. Stewing Saturday morning by the fax machine, Dan ran through scenarios where the prosecution asked to reopen the hearing, or that Detective Allen suddenly remembered advising Misskelley of his rights. He was surprised when no rebuttal fax from the prosecution appeared. A minute before noon, his phone rang. It was Judge Burnett, and he complimented Dan, saying that he had done a great job with the amended motion in brief. And he said, quote, "You will probably get me reversed by the Arkansas Supreme Court, but there's no way I can suppress that confession. Surely you understand I can't let this kid go." End quote. What the hell? He'd probably get him reversed? So you just rule on things that are absolutes and written in law and just kick it up to the Arkansas Supreme Court? I'm flabbergasted. I'm just absolutely flabbergasted. This was a blatant violation of Rule 2.3. Well, stunned by Burnett's candor, shocked senseless by this decision, it was clear that politics was more important than the life of an innocent, mentally challenged 17-year-old kid facing the death penalty. But Dan writes, quote, that he planted a seed that would become a giant oak tree in this case someday, end quote. Then Burnett conducted his press conference from his living room, saying that the Misskelley confession was voluntary and thus admissible.
Oof.
As all these legal machinations were unfolding, the frenzy of fear over the satanic panic continued, driving the local media even after the national press retreated. One reporter that Dan aptly nicknamed Maggot actually asked Stevie Branch's mom if she was considering suicide so she could be with her son. Oh God, that is just grotesque. And Maggot is actually a mild nickname for this guy. In Jonesboro, a Weccan bookstore owner was run out of town by protesters while Stevie Branch's biological father spouted Bible verses as if he were exorcising Satan to the recesses of hell. Rumors ran wild. West Memphis pastor Tommy Stacy said that Damien Echols had told him he'd made a pact with the devil and was going to hell, and this was reported widely. Now, I taught teenagers for 30 years, and if I had $1 for every time one tried to ruffle feathers and get attention, first with getting unconventional piercings, then dyeing their hair garish colors, then painting their nails black, then getting objectionable tattoos, all this being antsy teens, chasing attention and an identity. Oh, Lord. Christopher Byers' stepfather, John Mark Byers, quoting the Bible to a reporter, said that there are angels and demons on earth and that demons were in league with the devil, referring to Baldwin, Echols, and Misskelley. Pam Hobbs would say that the teens were Satanists. Quote, "Just look at them. They look like punks." End quote. You know, in the United States, we're supposed to be able to fly whatever freak flag we want, as long as it is done peacefully and lawfully. Now, I'm not a huge fan of Satanists, but we have religious freedom. This is a right under our Constitution. And this is what religious freedom means. Tolerating differences. That doesn't mean you agree with them, but it means that they can live peacefully in our country and believe what they want. And frankly, we've had a lot of very conventional religious people do terrible, horrible things to children, family, society. You know, that pesky thing about throwing stones in glass houses. All right, rant over. Now, Dan tells a story that broke my heart. With so many in Arkansas viewing these murders as both religious and a human atrocity, emotions were ramped up. Dan was asked to step down as packmaster for his son's Cub Scout troop. He was, after all, defending the Satanist. Now, mind you, Dan is from Paragould. He grew up in Paragould and was widely known in the community. And this is about 90 minutes away from West Memphis. So he's being slammed for doing his job, slammed for being a defense attorney, and fired from his voluntary position at the Cub Scouts. This is just so sad. Preparing for trial, Dan came across a letter from Inspector Gitchell, dated May 26th, after reading in the medical examiner, Dr. Peretti's report, that the victim's anuses were dilated, which, by the way, is perfectly normal when a body dies underwater, as the boys had. Gitchell had asked if the boys had been sodomized, and from this point onward, the West Memphis police took this as evidence of sexual assault, which was critical in fueling the growing satanic ritualistic murder theory. Now, this was an important development. Burnett moved the trial out of Crittenden County to Corning, Clay County, about 6 hours away. But this was a Pyrrhic victory, given that Jessie's family did not have the means to visit him there, nor was a hotel room available with the media snatching up everything in the vicinity. The victims' families were provided housing by sympathetic community members, but not the Misskellys. Fortunately, the pastor from the Corning First United Methodist Church opened his doors to them, with the clergyman explaining, quote, that this is what Christians are supposed to do. Jesus died for everyone, not just victims or defendants. I don't know anyone whose closets are free of skeletons. They were in dire need for God's grace, and we are here to give that to them, end quote. Well, God bless that pastor for his empathy and understanding. Jury selection began on January 19th, and surprisingly, this was accomplished by the end of January 20th. Now, a few weeks earlier, Greg and Dan had received a call from a jury consultant offering to assist for free, and they had developed a profile of the best possible juror, female, who were less likely to impose the death penalty. During voir dire, one potential woman juror stated that under no circumstances would she impose the death penalty. Relieved, Dan casually told Judge Burnett that this juror was good. When prosecutor Brent Davis agreed that she was good too, Dan immediately knew something was wrong, because that just made no sense. Another juror, who would wind up the jury foreman, looked like a hunter or a fisherman, and Dan hoped he'd question the lack of blood at the crime scene. Right before the trial was to begin, January 26, 1994, Joe Calvin, the deputy prosecutor for Clay County, offered Dan a plea deal. Quote, the state offered 50 years in exchange for Jessie Misskelley's truthful testimony against Echols and Baldwin, end quote. Presenting this offer to both Jessie and his dad, Jessie Jr. refused it. He could just not, quote, tell any more lies on Echols and Baldwin, end quote. The trial was on. The state's approach was simple. Present the awful crime scene photos and make the jury want to punish someone. They had two witnesses who could corroborate Jessie's confession. One was William Winford Jones, who told the police that a drunken Damien Echols confessed to killing the kids. Jones would recant this story just before his scheduled testimony, however. Vicki Hutchison, who had told the tale about going to the witches' meeting with Damien, would also recant her testimony. but shortly after the trial, and she would not go on record for over 10 years. The defense would point out the egregious errors made by the police at the crime scene, and then have alibi witnesses testify, hopefully with some effectiveness. And then Dr. Offshee would attack the confession as false, with Warren Holmes' testimony that Jessie had passed the polygraph. As Dr. Offshee began to testify, Judge Burnett went full out on team prosecution, limiting Dr. Offshee's testimony and that of Holmes. Burnett stated that he had already ruled that the confession was voluntary, so Dr. Offshee's disagreeing was really irrelevant. What this means is the jury would never hear this testimony. Oh my God! Dr. Offshee would testify without the jury present, his testimony in the record, so the appellate courts could see just how Burnett had prohibited Offshee and Holmes' statements and how detrimental this was to the defense. During a break, some reporters would tell Dan that their testimony was so compelling they thought he had won the case, and it was too bad the jury hadn't heard it. The trial continued, with a totally frazzled Dan holding on to a faint hope, riding this emotional roller coaster, knowing he had the life of this 17-year-old in his hands. What if Jessie got the death penalty on his watch? Deliberations began February 3rd. Later, Dan would learn from one of his criminology students at Arkansas State University, whose uncle was on this jury, that the first straw poll had 5 votes for acquittal. On the second day of deliberation, about an hour before lunch, the judge called Dan and Brent Davis to the hall outside the jury room. Judge Burnett knocked on the door, with the deer hunter foreman opening it. The judge told him he was going to have the sheriff get lunch for them and what would they like to eat. The foreman replied, quote, "We don't need lunch. We're almost finished," end quote. Burnett replied that he was sending, quote, "out for food anyway because you'll still have to come back after lunch for sentencing," end quote. What the holy hell? The judge just told the jury that Jessie was guilty and he was going to be sentencing him later that day. Well, the foreman got this and he replied, quote, "What if we find him not guilty? Will he have to stay?" End quote. As Davis went pale, looking faint, and Burnett frowned unhappily, hearing what was actually good news for the defense. No more words were exchanged, and the jury room door was shut. Totally gobsmacked, Dan told Greg what had transpired. Judge David Burnett had just created a mistrial by telling the jury that sentencing was required before a guilty verdict was reached. But, the foreman had absolutely signaled that Jessie was on his way to acquittal. So, how do you ask for a mistrial if your client is on the verge of being found not guilty? Oh, the conundrum. Quote, "We were both joyous and anxious as we huddled to decide what to do. It was an excruciating choice. If we asked for a mistrial, there was a good chance that we would get it. The prosecutors were looking completely dejected," end quote. And if the prosecutors thought they were losing the case, would they object to a mistrial? Likely not. Well, Greg and Dan, believing that they were about to win the case, decided not to ask for a mistrial, making what Dan called his biggest blunder in this case. At 11:54 a.m., February 4th, 1994, the jury returned with a guilty verdict. 1 count for capital murder and 2 counts of the lesser murder in the second degree. Evidently, the 7 jurors wore down the other 5 in a classic compromised verdict. Remove the death penalty, but find him guilty. Jessie was then sentenced to life in prison, plus an additional 20 years for each of the second-degree murder counts. A completely devastated Dan could only wonder, quote, what would the jury have done if it had not been for Burnett opening that jury room door? End quote. He promised Jessie in this moment, quote, I will never abandon you, no matter what, and I will get you out of prison one day or die trying. This isn't over, I promise. End quote. After the perp walk from court to the police cruiser en route to Pine Bluff Prison, Dan had a deputy roll down the window of the squad car, and he reminded both of them, Jessie is not allowed to talk to anyone. He is still Dan's client. Everybody got that, and everybody agreed. But off in a corner, he noted Davis huddled with two other officers, speaking in intense hush whispers, giving Dan a bad feeling. And then Jessie went off to prison, and Dan drove back to Paragould, weeping. Well, Dan got back home, and the kids were happy to have Daddy back. Dan, wife Kim, and 15-month-old daughter Catherine went to Walmart, with her playing hide-and-seek under the clothing racks. It was family, it was normalcy, but it felt terribly abnormal to a dejected Dan. A new battle had begun. Dan told the prosecution he was appealing Jessie's conviction, and he would not be testifying against his co-defendants. This now made Jessie's confession inadmissible in the Echols-Baldwin trial. The jurors would never hear it. Prosecutors Brent Davis and John Fogelman were in a tizzy because they needed Jessie's testimony badly. Now, repeatedly, Dan had told Jessie, do not talk to the police, remain silent. But this was not to be. A concrete thinker, there was no way he could understand the consequences of a decision to say this or say that about anything. He just didn't get it. The prosecution now explained to the victim's parents that Jessie needed to be enticed to testify. Thus, they wanted their consent to negotiate a lesser prison time sentence in exchange. Without his testimony, quote, all is not lost, but the odds of a conviction are reduced significantly, end quote. Davis would say it was really a 50-50 proposition. So understand that the prosecutors are going into a death penalty case feeling 50-50 about their evidence. This is not the 11 that Gitchell had claimed, and this is unconscionable. Well, Jessie was in prison for 3 days when Brent Davis called Dan, revealing that Jessie had confessed to Clay County deputies on the way to the Pine Bluff prison. Dan's head exploded. This after he adamantly warned them not to talk to his client, who had had his rights violated, and they'd again taken advantage of a man with a cognitive disability. Faxed a copy of this new confession. It was a jumble of content that had been presented during his trial, but together it made no sense. Meeting with Jessie in the assistant warden's office, Dan stopped Davis and Fogelman from joining. He would speak to his client alone. Asking why he talked to the police when Dan had told Jessie specifically not to, Jessie stared at the floor and he said, quote, I don't want to be here for the rest of my life, end quote. The deputies had told him that if he didn't testify, Echols and Baldwin would be set free, and only he would be blamed for the murders. And then Echols and Baldwin would be having sex with his girlfriend. And Jessie admitted, again, quote, I made it all up. It was a lie, end quote. Returning to speak with Davis, Fogelman, and Gitchell, Dan asked for a Bible. Acquired, Dan swore Jessie in, taking out a micro recorder. The 65-page transcript is now known as the Bible Confession. When you compare it to the actual known facts and then run it through the filter of Jessie's disability and the sources of the injuries on the victims' bodies, Dan writes, that dog just won't hunt. Dan and Jessie drew a map of the crime scene, with Jessie basically telling Dan what happened here and there. Nothing matched reality, a miserable failure. And what was painfully obvious is Jessie's complete unfamiliarity with the crime scene. Jessie Misskelley had never been to this site, ever. Speaking with Jessie Sr., Dan explained to him the pros and cons of Jessie Jr. testifying. Big Jessie knew his son was innocent and insisted that the plea offer should be rejected. With Jessie Jr. on board, Brent Davis was notified that Jessie would not be testifying in the Baldwin Echols trial. Glad that was over, Dan could now focus on the appeal. Only, it was far from over. Brent Davis now took the opportunity to tell Dan about the latest evidence. A jailhouse snitch named Michael Carson had come forward. While he and Jason Baldwin were cellmates at the Craig's Head County Juvenile Detention Center, Jason had confessed to the murders and sexual mutilation of the victims. What? Oh boy. On February 16th, without Greg or Dan's knowledge or consent, unbelievably, their client, Jessie, was brought from prison to the Craig's Head County Jail for the purpose of giving testimony in the Echols-Baldwin trial. By the time Dan figured out what was happening, these deputies would have 3 hours alone with Jessie to coerce him into testifying, telling Jessie the only way he'd get out of prison was, quote, on a stretcher after he died, end quote. Oh. February 17th at 6:15 p.m., Clay County Prosecutor Joe Calvin called Greg, saying that Jessie was in his office to give a statement, and did Greg want to be there? Notifying Dan, they were pissed to high heaven, and again, no statement would be given by the client without the attorneys present. Flooring the pedal to the metal, Dan raced to Joe Calvin's office, 26 miles away, driving way above the speed limit. Arriving, Fogelman was missing in action, but Brent Davis was there. Dan would speak with Jessie alone, and they were about 15 minutes into their conversation when Davis and Calvin burst in the room, insisting they were taking statements now, worrying that Dan would talk Jessie out of it. Well, gee, where did they get that idea? Jessie was confused, bewildered by all the push-pull going on, and this poor guy was unable to recognize what was in his best interests. He suddenly announced he was ready to make a statement, in spite of Dan advising him to remain silent. Now, Dan draws an analogy of stupidly calling an arsonist to put out a fire. He telephoned Judge Burnett, strenuously objecting to what was happening. Uninterested in Jessie's rights, Burnett said earlier he had granted Jessie, quote, use immunity, end quote. The prosecutors did not need the defense attorney's permission to speak to his client. Oh my God, this just gets worse and worse. In total disbelief, Dan listened as Jessie gave another new version of the events, differing from the original confession, from the police car confession, and from the Bible confession. The only commonality being that they all lacked cohesion and were absent of any narrative. At the end of the recording, Dan stated his opinion that Jessie Misskelley had just perjured himself. That night, the lead story on the 10 p.m. news, Jessie Misskelley had been brought up from prison in case he wanted to testify against his co-defendants, reminding everyone in the area that he had confessed and had been convicted. Dan would fill in Jason and Damien's attorneys. Then, arriving at the prison to talk to his son, Jessie Sr. was barred. Davis had cut off Jessie from his attorneys and from his familial support group, with Judge Burnett's cooperation. all the defense attorneys began drafting motions for prosecutorial misconduct. That Brent Davis had met secretly with Jessie behind Dan's back multiple times, and they learned he had gifted Jessie with cartons of cigarettes, their collective fury rising. Now, each defendant would file separately, as each had slightly different nuances to address. Dan's prosecutorial misconduct motion, filed February 23rd in Clay County, focused on 3 points of relief. 1. An order directing the prosecutor to have no more contact with Jessie Misskelley without Dan's knowledge and consent would be issued. 2. Judge Burnett should hold Brent Davis in contempt, punishing accordingly. And 3. A special prosecutor from the outside of the Second Judicial Circuit would be appointed to investigate these allegations. When the day of this hearing arrived, Burnett orchestrated the situation to ensure the media was out of earshot. Dan reviewed the timeline of the series of violations of the Arkansas and U.S. Constitution, with Davis not refuting any of it. But Davis did say he believed that Dan Stidham had lost perspective and wasn't acting in Jessie's best interests. And with that, Judge Burnett fired Dan, appointing Jonesboro attorney Philip Wells to determine if Jessie wanted to testify. Yes, he fired Dan. Now, meeting with Jessie Sr., the new lawyer Philip Wells, Dan, and Greg, Brent Davis offered a 40-year prison sentence total, with life being dropped. In front of all of them, Jessie said he didn't know whether Damien and Jason were guilty or not. Quote, "I can't lie on them no more," end quote. The exact same words he had spoken when he turned down the 50-year offer right before the trial began. Listening, Philip Wells reported that Jessie was not going to testify in the Echols-Baldwin trial. Is everyone clear on that this time? Brent Davis now asked the judge to deny the motions on prosecutorial misconduct, with Judge Burnett obliging. Is your blood boiling? Mine sure is. Arriving at the court early the next morning, Dan found Judge Burnett alone and warned him if a prosecutor or cop spoke to his client again, he would hold a press conference outside the courthouse and tell the whole world about the shenanigans going on. Burnett utilized his right to remain silent. Spring 1994. Damien Echols and Jason Baldwin were found guilty of murder, with many in West Memphis relieved. Defense consultant Ron Lax hosted Damien's attorneys, Val Price and Scott Davidson, and Greg Crow and Dan to a postmortem on the trials. What went wrong and what could have been done differently. All right, so fun fact. In 1984's Strickland versus Washington decision, the Supreme Court of the United States established a 2-part test for establishing the claim of ineffective assistance of counsel. A convicted defendant might show that his lawyer's performance fell below an objective standard of reasonableness, which then gives rise to a reasonable possibility that if he had performed adequately, the result of the trial would have been different. So this is reasonable crystal ball gazing. It isn't easy to pick yourself apart and admit, yeah, I suck. And Dan was desperately seeking normalcy, avoiding the spotlight and wanting to be a dad again, no longer stressed out of his mind. And maybe death threats would stop. While dealing with the appeal made doing all of these other things much more difficult. In addition to ineffective counsel, Rule 37, the violation of Rule 2.3 for not getting the Miranda waiver for Jessie Sr. since Jessie was a minor was still in play. With a 3rd grade reading level, it could also be argued that Jessie Jr. could not comprehend what a Miranda warning was in the first place, making the confession involuntary and inadmissible. Writing this Arkansas Supreme Court brief took 2 years to complete, with a gazillion T's to cross and I's to dot. It wasn't until July 1995 that they filed, and the waiting began. By fall, all of the reply briefs were in, with Greg and Dan requesting oral arguments before the Arkansas Supreme Court in December 1995. They were very optimistic of a favorable ruling. Back in 1993, working on another case, Dan had gotten Judge Burnett reversed by the Arkansas Supreme Court, the case dismissed in a 7-0 decision. So why not this time? Oh, and while all this was happening, the law offices of Stidham and Crow was dancing on the brink of bankruptcy. A little bit more stress to juggle. With meager public defender salaries, they hadn't had a case in months and resorted to refinancing their office building to pay income tax. Nor had they been paid for their work on the West Memphis case either. But slowly, the practice began to rebound, but they had really been sweating it there. April 22nd, with Judge Burnett presiding over the West Memphis 3 attorney fees and expenses hearing, Echols and Baldwin's attorneys received hefty payments of $30,000 to $26,000 each. Greg and Dan received $20,000 each, the least amount of any other team. In the end, they were paid $21.73 an hour, far less than Burnett had promised. They received $3,500 for out-of-pocket expenses, in spite submitting over $4,000 in receipts. Nor did they receive these payments promptly either, an utter disgrace. Warren Holmes got his airfare paid for, and Dr. Offshee would get $1,500. Challenged on how Burnett had arrived at these numbers, he refused to respond. In 1995, Greg Crow left to open his own law practice, but agreed to continue assisting with Jessie's appeal. And meanwhile, Jessie was having a hard time adapting to prison life. He was just an easy target who happened to be a convicted child killer. Threatened, he'd once left a panicky message that they were going to kill him that night. And Dan spoke to the warden, who placed Jessie in protective custody, which is safer, but isolating. So on December 18th, 1995, on a cold, misty day, oral arguments before the Arkansas Supreme Court began. In his brief reply, the Attorney General had argued that they had failed to obtain a ruling on a key issue, the Rule 2.3 violation, which was plainly incorrect. Dan had specifically drafted an order on that specific point following the suppression hearing, and it stated clearly that Burnett had considered the amended motion and brief to suppress Jessie's confession, rejecting it. Well, again, Dan and Greg felt confident. Now, earlier, Greg had once worked as a clerk for a Missouri Supreme Court judge, discovering his superpower. Greg had this uncanny ability to call the decisions in cases presented, reading faces and body language of the judges. Rarely was he wrong. And he told Dan today they had either won 4-3 or lost 3-4, and time would tell. February 19th, 1996 came the ruling. The Arkansas Supreme Court affirmed Jessie Misskelley's conviction in a unanimous 7-0 decision, leaving Dan and Greg shocked senseless. It got worse. Its ruling on Rule 2.3, which should have triggered an automatic reversal of conviction. The court concluded that they had not raised the Rule 2.3 issue in a timely fashion, nor obtained a ruling from Burnett on the issue. Both points completely wrong. I mean, did the justices not read the brief? Had they skipped a page? It was all unquestionably in the official record. Well, Greg and Dan would just point out the oversight and get this corrected. So immediately, they drafted a motion for rehearing, pointing out the exact pages and paragraphs in the record of the appeal where these documents were, and more hurry up and wait began. April 1st, 1996, which happens to be April Fool's Day, the Arkansas Supreme Court response came, quote, "The Rule 2.3 issue would not be addressed again on rehearing," end quote. I have no words. Is the entire state of Arkansas's legal system corrupt or stupid? And Dan crashed. I mean, the sky is falling, and it was his fault innocent Jessie Misskelley would be in prison for the rest of his life. But Greg realized something, saying simply, quote, "You know, Dan, they can't have it both ways," end quote. A puzzled Dan listened to Greg's explanation about Rule 2.3. Quote, "Either we raised it or we didn't. They can't have it both ways," end quote. If they raised it properly, Jessie would have gone free. But the court ruled that they did not. Thus, they provided grounds for an automatic new trial based on irrefutable evidence that Misskelley had received ineffective assistance of counsel, and Jessie now goes free. Well, that's true. It's true. I see what he's saying. But bitter and second-guessing his decision to become a lawyer at all in a corrupt, broken system, this seemed like a hoax. Justice didn't exist. This was all a sad joke. But Dan had promised Jessie he would never give up. He'd made a commitment. So Dan Stidham would fight on, picking and choosing his battles. Admitted to practice before the U.S. Supreme Court, Dan learned that Justice Clarence Thomas was assigned the case. The clerk Dan spoke with was very excited. She had seen the newly released HBO documentary, Paradise Lost, The Child Murders at Robin Hood Hills. Now Dan was receiving cards and letters and thousands of emails from across the globe that were supportive, because times do change. In October 1996, Dan learned his writ of certiorari was denied. And the clock was now running. And Dan couldn't find an attorney to represent Jessie's ineffective counsel claim either. And then Damien and Jason's convictions were affirmed by the Arkansas Supreme Court in another 7-0 decision. But hope was building as the Paradise Lost film triggered a countrywide Free the West Memphis 3 movement. Paraphrasing now, the tiny cracks in the prosecution's case that emerged in 1996 expanded mightily when Paradise Lost Revelations came out 4 years later. Dan's pariah status was beginning to fade too, replaced with a grudging respect for an attorney fighting the good fight for justice. By now, prosecutor John Fogelman had been elected a circuit judge holding court in Greene County. And in November 1996, the Phoenix Times quoted Fogelman as saying, "There was a remarkable lack of physical evidence against anybody," end quote, in the West Memphis 3 case. You think? But the guy still got a promotion. With this shift in attitude, new suspects emerged. John Mark Byers, Christopher's stepfather, and Terry Hobbs, stepfather of Stevie Branch. Now, both of these families had had a share of tough times, topped off with the murder of their sons, and now ugly public scrutiny that had to be horrible to live through. The truth was, violence had been a part of the Byers and Hobbs families, but neither man had been investigated at the time of the murders. Byers' commentary in Paradise Lost 1 and 2 was bizarre, raising many eyebrows. He had been previously arrested on drug and weapons charges. Both John Mark and Melissa Byers had been charged with burglary, robbing antiques from their neighbor's home, and pawning them. Melissa Byers would die under mysterious circumstances, her autopsy creating more questions than it answered. Arrested for selling drugs to an undercover police officer, John Mark Byers would do his time in the same prison that held Damien and Jason. Terry Hobbs pleaded guilty in February 1995 for shooting his brother-in-law, wife Pam's brother, who had confronted him for beating his sister, and much of this played out in the public arena. By now, a Free the West Memphis 3 webpage was running, selling iconic black t-shirts with mugshots of the three that were being worn. In 2003, a huge fundraiser in a Los Angeles art gallery opened called Cruel and Unusual, an exhibition to benefit the West Memphis Three, hosted by Winona Ryder, who spoke passionately about the case. This was covered by the BBC, USA Today, People magazine, Rolling Stone, Celebrity Justice, and the Associated Press, raising $20,000 for the defense fund. As the appeals process pittered along, Dan felt he was viewed as Don Quixote tilting at windmills. And he wasn't exactly wrong. His dad told him that people were talking about his obsession and that he needed to let it go. But when he told his father that Jessie was truly innocent, his dad got it. Not long after, Dan learned that Jason Baldwin's attorney had forsaken him, and that was problematic. The same clock ticking for Jessie's Rule 37 petition, the ineffective counsel petition, was also ticking for Jason's. Without a single attorney being willing to assist, Dan had to do it himself. So October 1996 saw him drafting Jessie Misskelley's pro se Rule 37 petition. So ostensibly, Jessie is representing himself against Dan. And he drafted one for Jason Baldwin, having no idea if Jason would sign it or not. I mean, would the lawyer of the guy responsible for you being arrested be a welcome sight? Well, arriving at the Arkansas Department of Corrections, Dan learned that Jason would speak to him. Introducing himself, Dan confirmed Jason had no representation, and then he explained what the Rule 37 petition was, ineffective counsel, and why it needed to be filed, and it could result in a new trial. Jason now gave Jessie's attorney the side eye, and Dan swore he believed in his innocence. Well, Jason took a leap of faith and decided to trust Dan, and the two would begin a friendship that lasts through this day. On his way home, Dan filed Jason's 37 brief and then Jessie's in Corning. Misskelley's pro se petition declared that Dan Stidham was ineffective as he had failed to raise the Rule 2.3 issue in a timely manner, which the Arkansas Supreme Court already stated in their opinion confirming the convictions. And guess who would oversee the disposition of both Jessie and Jason's Rule 37 petitions? Judge Burnett. Dan braced himself for more malfeasance. But there was a rumor that HBO's Berliner and Sinofsky were preparing for another documentary. So, 4 years after the first film, came the second, with the cry for justice becoming more strident and more organized. And Dan knew that Burnett would not be able to resist placing himself at the center of attention again. Dan was now suffering from nightmares, waking in a cold sweat, seeing 3 dead boys with glowing pale skin at the foot of his bed. Fluttering in his chest launched a litany of tests, including radioactive thallium and CAT scans of his heart, with no problems detected. Panic attacks, stress, anxiety, a side effect of the murder trial, was diagnosed. To de-stress, he hit golf balls and went fishing. But nevertheless, his trips to track down an expert on this or on that conflicted with his kids' schedules, with Kim unhappy, their marriage devolving. Dan's fragile emotional health took a severe hit on March 24, 1996, when a school shooting occurred in Jonesboro. 2 boys, ages 11 and 13, armed themselves from one of their grandparents' gun cabinets, pulled the fire alarm, and then waited for students and staff to emerge, ambushing them. 4 classmates and a teacher were killed, with 10 other students injured. Dan wrote, quote, "Had the world become so evil that children were not safe to ride bikes or attend school?" End quote. And the media once again descended on Northeast Arkansas, covering a story involving dead children. Just overwrought, Dan sought out his pastor. Quote, "Why would God let something like this happen to innocent children?" End quote. And the reply was Dan just had to have faith. But Dan was just about out of faith. He understood that his anxiety and despair was nothing compared to those who had lost their children, nor Jason, Damien, and Jessie, but he was trying to cope nevertheless. Then he received a letter from Jason, struggling in prison, wondering what had gone so terribly wrong, saying he just wanted to go home. But Jason wrote that he refused to lose his faith, that word again, and now Dan felt petulant by comparison. He would press on. In August 1997, Dan attended an Arkansas trial lawyers event. In the buffet line, a man approached him, asking how Jessie Misskelley was making out. About as well as can be expected, Dan muttered. The man motioned to him to come and speak privately. He told Dan, quote, "You know, you didn't really lose that case," end quote. What? Dan told him he lost in a 7-0 decision, but the man continued, quote, "Actually, it wasn't. You won that case 4-3, end quote. Catching his jaw before it clattered to the floor, Dan listened as the man explained. A family member was a law clerk for one of the Arkansas Supreme Court justices, and he had been in the room when they voted. Quote, "You won the case 4-3, end quote," he said again. It hit Dan that Greg Crow's prediction had been accurate after all. So wait, what happened? The man said, quote, "The justices got scared. They started discussing the inevitable backlash they'd get for letting Misskelley go free. They all became afraid of what would happen when they each had to run for re-election," end quote. Son of a bitch. Feckless, immoral cowards. They took an oath to uphold the law and Constitution, and their future election was more important than justice, than a 17-year-old kid's life? All right. This case, oh boy. Let me remind you, this is only some of it. You have to read the book yourself, and you just need to read this. Now, this man would vanish into the crowd, and Dan would never see him again, but his mind was blown. And heading home, he called Greg Crow, who said, quote, "I knew it was 4-3, end quote. Next, because Arkansas has a prosecutor-controlled crime lab, Dan emailed Brent Davis asking permission to obtain autopsy photos. Davis got snarky, asking for proof that Dan was still representing Misskelley and why he wanted it. All right, these people are ticking me off. After jumping through Davis's hoops and $1,600 later, Dan shared the photos with Damien's attorney, Ed Malik, who had helped pay the $1,600. February 1998, a trip to the West Coast came up, with this not going over well at home. Now, Dan's description of this conference reminds me a little bit of CrimeCon. Quote, "An Oscar ceremony for all-star forensic scientists there to seek help and bask in adulation," end quote. Well, Dan went anyway, engaging in a little stalking. He spotted Dr. Michael Baden, world-class forensic pathologist. I know that feeling of spotting your hero in the crowd. And Dan came over and asked if he could speak to him about a case. But Dr. Baden declined. He was off to a meeting, perhaps later that afternoon. Dan also spoke with Dr. Thomas David, a forensic odontologist who was consulting with Damien's attorney, Ed Malik, about the supposed bite marks on Stevie Branch. He also met Dr. Neil Haskell, a forensic entomologist, so think a forensic bug guy. An hour later, Dan saw Baden, Haskell, and David all walk into an elevator. Well, carpe diem. With the pathologist trapped in the elevator, Dan made it his impassioned plea and even mentioned Paradise Lost, and was rebuffed by Dr. Baden. Dan persisted. Could he take a quick look? Just 15 minutes. His case materials were on the 17th floor. Well, by now, David and Haskell were intrigued. Pinching himself, Dan had all three world-renowned experts standing in his hotel room. He spread out the autopsy and crime scene photos, mesmerizing the assembled. Baden said he had conducted over 10,000 autopsies during his career, and these were the worst photos he had ever seen, with David and Haskell seconding his observation. Looking at the photo of Christopher Byers with his genitalia missing, Baden said that this looked like animal predation, and Haskell added it could be anything from crayfish to turtles, depending on how long the bodies were submerged. They kicked into a discussion on other wounds, scratch marks made by animals, maybe a raccoon, and many of these wounds were post-mortem, occurring after the boys were dead. And all three asserted that this crime was committed by an adult, not three teenagers. Baden gave Dan his card, telling him to send him everything, and he would give him his thoughts and maybe recommend a consultant he could work with. After Baden and David exited, Haskell and Dan went down to the bar. Yeah, I need a drink after this too. Dan got a lesson in how fast insects are drawn to a corpse. In Antarctica, Haskell had done experiments where blowflies appear in minutes, laying eggs in the body of a seal. Well, that begs to ask, where do blowflies live in Antarctica? Well, fun fact, Antarctica does have one native insect, a mite, Belgica antarctica, that survives freezing cold. Haskell also further suggested to Dan that they conduct an experiment in the same creek with a dead pig, and then observe the creatures that show up to feed. Dan was elated. He felt the case had made more progress in 2 days than it had in years, and he shared his newfound knowledge with Ed Mallett, Damien's attorney. And that concludes episode 103. I hope that you're gaining a greater understanding of what went down behind the scenes in this case. I am disturbed, I am frustrated, but justice is coming. In 2 weeks, episode 104, Paradise Imperfect, part 3 second cast will drop, and it is worth the wait. Now, some of you have asked how you can help. Well, introduce your family and friends to the Murder Shelf Book Club podcast. You can leave comments now on Spotify, nudge, nudge, nudge. And I just want to thank you for being with me on our journey together into the stories, the updates, and analysis on the best true crime books out there. It is a joy for me to be doing this. Email me at jill@murdershelfbookclub.com or find me on X, Facebook, Instagram, and YouTube. My sources, photographs, and all kinds of information are found on my blog at www.murdershelfbookclub.com. See you in 2 weeks, guys. Written and produced by Jill, all rights reserved. Music, The Pewter Elephant by Blue Dot Sessions.